Hi, everybody. I want to apologize first for not having a PowerPoint for you. It's difficult for me as a lawyer to share my screen because I have things popping up that are confidential occasionally, and I have to find a way to turn all of those off so that I can screen share. So I do have materials, and I understand they can be circulated after. So you know, I'm working from something, and I will pass some materials along for anybody who's interested. A little bit about me. I'm an employment and workplace human rights lawyer. That is all I do day in, day out. My firm has been advising lots of employers and employees on COVID-related issues, including layoffs, terminations, how to deal with some of the programs, how that'll affect uh, you know, how one program can affect the other, or what, you know, strategy you should be using for dealing with it, what's best for you and your business. So that's just a little bit about us. What I'm specifically speaking about today is terminations, layoffs, and rehirings. So I'm sorry if I'm speaking quickly. I'm going to try to slow down. I talk about these issues all the time, so I am very comfortable speaking about it. So um, starting off with layoffs. So generally speaking, an employer does not have the right to lay an employee off, okay? That is the general starting point, is an employer doesn't have the right to lay an employee off, which is a temporary, you're not going to be working. There are exceptions to that, and the general exceptions are if you have the right to lay off in your employment contract, if your employee agrees to a layoff, or you are an employer in an industry where layoffs is common. So for instance, seasonal workers. It's very common, or you tree planters, you know, it's something that temporary layoffs happen. If you're not in an industry where temporary layoffs are common, you don't have the right to do it unless you are you have that in your contract. Very, very few contracts include that right. So what does that mean? Does that mean that you cannot temporarily lay somebody off? No. What it means is if you do and they do not agree to it, they could bring a claim against your company to say that this is effectively a dismissal. That kind of legal claim is called constructive dismissal. And the test for it is, did you unilaterally and fundamentally change a term of their employment? So if you lay them off completely and they have no work, that would be a fundamentally unilateral change to the term of their employment. And you could owe them severance. Okay, so if they don't agree and you lay someone off, they could bring a claim against you for severance. Okay, so how much severance could you owe someone? There's three places I look to see that, and it also depends on whether or not your employees are governed by legislation. So for instance, the three places are the applicable legislation. Most often in BC, that would be the BC Employment Standards Act, but for some industries that could be the Canada Labour Code. They have different requirements. Then I look at your, so the first place is the legislation. The second place is your employment contract. A lot of employment contracts include, if we're going to terminate your employment, this is what we will pay you. And the third place is the common law. Common law is judge-made law. It's judges looking at people like your employee and deciding how much notice they would need to replace their job. The applicable legislation. So the Employment Standards Act is the what's going to apply to most people in BC if you're a BC employer. But there are certain professions that are excluded from the provisions in the Employment Standards Act, such as accountants or lawyers. So depending on whether your employees are excluded or not, there could be some other layers to that. But you could owe someone severance, and how much severance you owe, you look at those three places: the legislation, the contract, and the common law. If you have a well-drafted contract, you can owe very little in severance. For a short-term employee, it could be a matter of weeks. For a long-term employee, if you do not have a well-drafted contract, you could owe as much as 24 months. severance to someone. So it's something that you should look at carefully before you do, and have discussions and see if you can get people to agree to layoffs if that's the way that you're going to go. Because if you crystallize someone's claim by letting them go, or by laying them off, you could crystallize a claim to severance, which could be a very, very significant liability for you. So what to know about layoffs is, if you do have the right, temporary layoffs can be a maximum of 13 weeks, after which it's a termination. Then this is under the Employment Standards Act of BC. Again, if you're in a different province, there's different legislation, or if you're in an industry that's not regulated in BC. So for instance, banking is regulated federally. The federal legislation, the Canada Labour Code, would apply. But in BC, you could, after 13 weeks, it's a termination and you could owe someone severance. There is a saving provision in the Employment Standards Act that says that it's not a termination that means that you owe someone severance if the contract becomes impossible to perform due to unforeseen circumstances. So what does that mean? Impossible to perform, it's not, this was, we had a little bit of an economic downturn. It's a pretty high standard. And whether or not that's going to apply in COVID circumstances, there's been a few directives from the government on that. But that's only for the amount that you would owe someone under the Employment Standards Act. The kind of claim that they could have to say this is constructive dismissal, there's one other kind of, they could have a claim under the Employment Standards Act for severance pay. They could also have a claim for constructive dismissal termination pay under the common law. And that, a defense to that as an employer could be, well, the contract is frustrated because it became impossible for anyone to do the work. Generally speaking, an employer does work and they get paid for doing work. The employer does work, the employee does work, the employer pays for work. And where that cannot happen, there's this defense called frustration. The contract has been frustrated. How that's going to play out, we don't know yet, but there's certainly some people speaking about that right now, some lawyers debating about whether or not COVID may create that defense to these kinds of claims. But these kinds of, can I just terminate people? Can I lay them off? If you terminate an employee because your business had to completely shut because of COVID-19, there may be some, you may be saved from some of your severance obligations through defenses like frustration of contract and this provision that says in the Employment Standards Act that says that the contract became impossible to perform. But if neither of those apply, or you can't reach the high burden it is to prove that, then you could owe people severance, and severance could be anywhere depending on how long the person has worked for you, how old they are, what kind of duties and responsibilities they have, and how hard it's going to be for them to find a new job, the availability of alternative employment. Those are the key issues. Depending on how those factors shake out, you could owe anywhere from, nothing for an employee who's worked for you for under 3 months, who has a very well-written contract, to 24 months. So these are issues that you should certainly, if you're looking at laying off or terminations, you should certainly try to get advice. What I can tell you up front is if your employee will agree to a layoff, get that in writing. If they're going to agree to it, that wouldn't necessarily trigger a severance because they're agreeing to this. So that's one way to deal with it. I have employers who are offering people retention bonuses and things like that. So we'll lay you off, but we'll give you a bonus when you come back. We really hope to have you back. There's lots of different programs now that you can look into as opposed to layoffs and terminations, which I understand you've been talking about. So, those are from my perspective, the things that I want to tell you about how you can do it and what your risks are with layoffs. If you can get your employees on board with a layoff, or you can get them agree to it, you're going to be in a much better position. If you have it in your contract, you're in a much better position. If you don't have those things, you know, how to best navigate those situations is something you should probably try to look for some advice on. But the general points that I can make are: be careful what you do. You don't want to trigger a termination of a 25-year employee who's in their 60s who has no contract. You could have huge liability to that person, especially if they took some advice from someone like me. I act for employers and employees, so I see both sides of this argument every day. And this is one of the biggest areas of liability right now, is potential severance pay. So there is something called, I just want to touch on quickly, called the duty to mitigate, which is employees have the duty to go out look for a new job. And if they get a new job, their severance, the amount of severance you would owe them can be reduced significantly. So that is, you know, a very important point. If you are looking at this and you know that they could walk into something somewhere else. But again, layoffs, we act for employers. We've been, some employers are having people agree, some people are doing them anyway. Some people don't have a choice. You know, we try to say things like, we really value you, you're a fantastic employee, we hope that we'll have you back as soon as we're back up to speed. You can try to have people agree to hour reductions as well. If they don't agree to hour reductions and you cut their salary by more than 20%, that could also be seen as a unilateral fundamental change to the terms of their contract, and that could trigger your obligation to pay them severance. So all of these things are very, you know, they're risky, unless the best way to manage them is to try to have open dialogue and agreement. And if you can get agreement from your employees, having things in writing is really important to defend any claims like this was a termination. Another thing about layoffs that you need to be mindful of is, you know, if you've got a problem employee who that's the person who you want to lay off. If the reason they're a problem employee is because of something that is protected under human rights legislation, so for instance, they have a disability, or they're pregnant, or they have been a thorn in your side because they've been making complaints to WorkSafe or anything like that. Choosing them as the employee who gets laid off right now is dangerous, because there's protections under the Human Rights Code and under WorkSafe legislation to say that you can't discriminate against those people. You can't make the decision that way for those kinds of discriminatory reasons. So, you know, there's other things that you can think about, like alternatives, if you can pivot your business model, reducing labor costs. There's other kinds of potential things that you could do to reduce your costs, such as, what are you offering a bunch of benefits that people can't actually use right now, like dental? You know, there's very limited dental access right now. It may be possible that you can reduce some of those fringe benefits to save some money. That's something that you should certainly consider and take, you know, advice from the appropriate professionals on, but that's, you know, an option. One other thing about layoffs is if you reduce someone's hours significantly, that could reduce potentially their entitlements to EI later. So just be careful about what you're doing that way. With the CERB right now, there's pretty set defined amounts being paid. But if CERB runs out and we go back to the traditional model of EI based on how much people were earning, their employment insurance benefits could be worth less because they weren't earning as much because you cut their hours. And that could just be something that upsets them. Anytime an employee is upset, you're more likely to get a problem or a claim. Yeah, there's lots of other alternatives that I'm sure you're learning about. I think that's about probably enough of a summary of the things that I wanted to cover. I'm sorry I went a little over, and I'm sorry I speak very quickly. I do have some notes on stuff like this, and my firm's been very active in blogging about these issues. So I invite you to look at our blog. We've got 4 or 5 or 6 now specific blogs on these kinds of issues because of COVID-19. They're really useful general information, and I'll share a link for them as well.
If I can ask a question from Christie.
Yes.
I have here many of our clients that it mix the terms termination with a layoff. Many people use the term layoff for both things. Can you clarify what is the meaning of each one of these two words?
Yeah, so a termination is where you're finally ending someone's employment, okay? So they're not going to work for you anymore. There's no continuing obligations. You pay them what you owe them. So you pay them for all hours they've worked. You pay them any outstanding vacation you owe them. You pay them any severance that you owe them under their the Employment Standards Act or their contract. And that's it. It's the end of their employment. A layoff is generally something where you're saying, we don't have hours for you right now, but you're still an employee. You continue paying things like benefits if you can. You know, those kinds of things can be addressed by contract, but generally you keep paying, they keep gaining seniority, they keep earning towards vacation, things like that, but they're not receiving hours at the moment. That temporary layoff, a layoff that is not temporary is a permanent termination. So a layoff that is not temporary is the same thing as firing someone. It's just a gentler word. A temporary layoff can only be done for a short period of time, 13 weeks, maximum in a 20-week period under the Employment Standards Act BC. I keep saying that, but what I'm talking about is specific to BC. There are different rules for different provinces in different countries. So certainly if you're international, you need to get advice specific to you. But for a temporary layoff, it's generally, it's only allowed if it's common in the industry, if the employee agrees to it, or if you have the right in your contract. Otherwise, it can be seen as a full-on termination and it can trigger your severance obligations.
Well, I would like to thank Christie Gilmour for joining us on this presentation today. And thanks to her firm, Forte Law, that is a boutique firm in Langley, specializing in labor law. So if you need assistance, we will have that information of Christie and CV posted in our page, and probably you can talk about more about that, Eli. And thank you, Christie.
Thank you so much, Christie. Thank you for sharing your insights. Sounds like there are definitely some options on the table for business owners to consider. So yeah, we'll be doing a follow-up posting about this on our website, and maybe there we can share your information package or your material you mentioned.
Perfect.
Yeah, so excellent. That's all the time we have for today. So thank you, Jim. And again, Christie, thank you so much for giving us your time. Cheers. And thank you as well to all of our attendees for giving us your time too. And please be sure to check out our website for the follow-up to this. And we'll see you all next time. Thank you.
Okay, great.
Thank you, everyone. Thank you.
Cheers.